And at this point, we can start with today's event, which is entitled The Problem of Execution of the European Court of Human Rights Judgments in Greece, Bekir Ousta and other groups of cases. It is organized by the Association of Scientists of Western Thrace and the Greek Helsinki Monitor. We will discuss this problem of execution of the European Court judgments with a special reference to the Bekir Ousta. It is a long story. As you know, we're talking about a very old association, the Cultural Association of Turkish Women. And so we will focus on the non-execution of the judgments such concerning the Bekir Ousta and other group of cases. So we will start with the addresses. I will try to monitor. I'm Jean Okhmetoglu. I'm a journalist and chairman of the Union, Turkish Union of Xanthi. We will have two addresses, Mrs. Hussein Baltaji, and we have Mr. Oglu. And of course, we have three speakers who will participate today, and we would like to thank them. Mrs. Maria Yanakaki, who is a specialist, expert on human rights. And we have Mr. Panagiotis Mitras, spokesman of the Greek Helsinki Monitor, and a member of the board of the European Implementation Network, and Mr. Ahmed Kara, attorney of Bekir Ousta and other groups of cases. So I would like to start. I will give the floor to the first persons who will address the audience. So I will give the floor to Mr. Khalid Habiboglu, President of the ABTTF.
Dear participants, my country is one of the most beautiful and cutest countries in Europe, but it is not open to multiculturality at all. On the contrary, unfortunately, it sees different culture as a danger. For this reason, three of our associations under the name of the Bekir Ousta and other groups of cases applied to the European Courts of Human Rights, and the court had ruled in 2007 and 2008 that the freedom of establishment association of our three associations had indeed been violated. One of these three associations, the Xanthi Turkish Union, is our oldest association founded in the region. It was founded in 1927. Its sign-board was removed in 1983. It was officially closed in 1986. The other two are new associations. The Turkish Women's Cultural Association in Rodopi province was founded in 2001. If it had been allowed to be founded, this year would have marked its 20th anniversary. Our other association, the Evros Province Minority Youth Association, was founded in 1995, but the court rejected its application for establishment. Although the European Court of Human Rights has ruled that our country has violated the right to form an association for our three associations, our country has yet not implemented the judgments emanating from European Court till this day. I cannot understand the situation in my country, which is a member of the European Union. This panel will allow the issue of the implementation of European Court of Human Rights judgments in our country to be discussed in detail within the Bekir Ousta and other groups of cases. I hope that after today, our country will take a concrete and clear step towards the implementation of human rights judgments in the Bekir Ousta and others group of cases. Thank you.
Thank you, Mr. Khalid, for your short address. At this point, I will give the floor to another co-organizer, who is Mr. President, Mr. Baltazis, will take the floor. Thank you very much. I would like to thank the participants, Mrs. Yanakaki, Mr. Parinagiotis Dimitras, Mrs. Houliamin, Mr. Adepoglou, the president, who also participates remotely, the co-organizers, Mr. Ahmetoglu, Mr. Ahmed Kara, and all the distinguished scientists and distinguished people of the minority and Greece. It's a great honor for us to be together, even remotely. As a president of our association, and as a member, as a simple citizen of the Western Thrace, as a Turkish member of this Turkish minority of Western Thrace, and additionally, as a young person, because that's how I feel at least, unfortunately, the problem of our identity persists. And we experience this situation since 30 years, and it continues. And we're tired of that. Because we cannot, we shouldn't be pessimistic. Being young people, we will continue to dream, and we will continue to hope for the best in the future. We hope that the Turkish minority of Western Thrace is a wealth for Greece. It is wealth for Europe, and it's a wealth for the democracy of this country. And this paradox should end because we shouldn't forget that Greece is the country of democracy, and it should be an example for the rest of Europe, because Europe is based on the principles and the values of ancient Greece in terms of democracy. Recently, I read an article of this. It was like a light in the dark situation that we experience. And I read that some politicians consider that this problem should be settled once and for all. Greece is one of the countries that doesn't execute the judgments of the European Court on Human Rights. So this was like a beacon of hope, and I really hope that we, as an asset, as a wealth of this region, we will be the common denominator, and we will be the liaison, and we will serve as guarantors of peace, stability, and multiculturalism of this region. So I hope that next time we see each other, things will be different, and the things will change, that will allow us to be optimistic for the future. Thank you. Thank you very much. Your contribution was very significant. So now, Mrs. Houliamin, who is the president of the Turkish Association of Women of Rodopi, will take the floor. She's the chair. on behalf of Bekir Ousta and other groups. First of all, I'd like to thank the bodies that organized this online event panel, and I hope that today's event will be the beginning for a more open and more constructive discussion on minority associations awaiting the implementation of the decisions of the European Court of Human Rights. The Bekir Ousta group of cases concerns 3 minority associations. The one quite old, almost the same age as the Treaty of Lausanne, while the other 2, well, I'd like to call them like newly established, but unfortunately these are 2 associations that have experienced, that have made many time-consuming efforts to register in the registries of associations without having succeeded to do so far. The term Turkish in its title is the reason for the abolition of the Turkish Union of Xanthi, which was founded in 1927 and has operated for more than 50 years under this name. But also, this title is the reason for the non-recognition of the Cultural Association of Turkish Women of Rodopi, founded in 2001. Same thing applies for the Youth Association of Minority of the Evros, although it doesn't use the term Turkish in the name, but only the word minority. The first minority NGO was the Turkish Union of Xanthi, with members in the first year of its establishment, and from the majority, such as Michael Penoglu, assistant lawyer, Spiros Giannakopoulos, to journalist. In its musical groups, there were members such as Mr. Metsurian, Mr. Georgiou. The music teacher was Mr. Kozomjoglu. It used to have a football team which qualified for the first amateur division, and some of its coaches were Mr. Theodoridis and Mr. Tsagaridis, and one of his players was Christos Tsagalidis. But today, this association is called illegal, self-proclaimed destabilization arm and threat to public policy and national threat. The case of the Cultural Association of Turkish Women that wishes to establish a meeting place for the women of the minority, to work for the social, moral, and mental and spiritual uplift of these women, and to create brotherhood ties between its members, has become a judicial tug of war. The effort to establish a women's association with a purely cultural orientation has taken a political character. As a result, a long-standing vision of the local women has been lost in the court files. The woman of the minority has lost the opportunity for the time being to organize an association, which by its nature would help her promote her rights. We're talking about a woman who, in addition to the problem faced by women worldwide, has her own particular issues to solve. The Youth Association of Evros, which aims at promoting and protecting democratic and human rights, preserving the traditions of the minorities, strengthening social cohesion, and promoting friendly relations with other communities, especially with the Greek majority, expects on its part the day of its registration and operation. The Turks and the Cultural Association of Turkish Women for 13 years, as well as the Youth Association of Evros for 14 years, are awaiting the implementation of the judgments of the European Court of Human Rights. In fact, currently the term of POMAX and Roma are accepted by the Greek state, the same Greek state which insists on non-implementing the judgments of the European Court in the case of Bekir Ousta and other similar cases. Well, let's make it clear, these associations are not instruments of anti-Greek propaganda. And I think that it's a great injustice for members of these associations to become target and to be projected as dangerous individuals for the Greek society. Well, this is indeed a big issue in the daily lives of the people who are associated with this association. To conclude, I would like, as a person, to say a few words. When the Turkish Women's Cultural Association of Rodopi was founded. I was not married. I was single. Now, today, I have a 16-year-old daughter, and I have a marriage of 18 years. I have a girl who was born in 2001 and is now 20 years old. So the next appointment with the Supreme Court was set for March 2022. And if we're safe and sound until then, we will see what happens. Thank you for your patience. Thank you for indulging me. Thank you very much.
Μικρό παιδί στο δημοτικό.
So I was 6 years old. I remember the Turkish Union of Xanthi. When the flag was removed from the association, I was 10. Ever since, 38 years have elapsed, and every time I enter the premises of this association, I feel very curious, I'm wondering if this flag will find its place again. I hope that I will be able to see this flag before I retire. So at this point, we can move to the keynote speakers. We have Mr. Ahmed Kara, who is attorney of Bekir Ousta and other groups of cases. Ahmed Kara was born in Xanthi. He went to the elementary school of the minority in a small village of Xanthi, and then he went to the minority high school, and he graduated in 2001 from the law school of Ankara University. Also, he graduated from the University of Anadolu, International Relations. He is a lawyer in Xanthi, and he practices this profession ever since. And he's president of the Cultural Association of Xanthi from 2010 to 2013. So from 2016 to 2019, he's been a lawyer of the Bekir Ousta case. So, dear Ahmed, I will give you the floor. Thank you very much. I listened with great attention the previous addresses. Mrs. Amin is very well aware of all three cases, and she made a good analysis very briefly. As an attorney of these cases, and I've been in charge of these cases since 10 years. So in this capacity, I would like to make a short review and then explain to you what the situation is currently. As you all know, the Turkish Association of Xanthi was founded in 1927, and until 1983, it operated normally with no problems and legally. Unfortunately, in 1983, with an application of the then prefect, it was considered that the title was a threat for legal order, and unfortunately it was decided to dissolve this association. Before I move on to the legal dispute involving this association, let me tell you that in 1995, the youth of a minority of Evros was founded, which in its title did not include the word Turkish. Unfortunately, the domestic courts considered that this association with this name poses a threat to legal order and didn't allow it to be registered. Same thing, of course, with the Association of Women from the Rodopi in 2001. So, of course, legal proceedings were initiated, which are still pending till now. As for the first association from 1983 to date, all these years have elapsed, and even though the European Court on Human Rights ruled and judged that there is a breach of violation of Article 11 in all three cases. Unfortunately, since 13 and 14 years ago, these judgments were not executed. Our country, unfortunately, with different pretexts, tries not to execute these judgments. Even though the Council of Ministers, which has been monitoring the implementation, the execution of these judgments 4 or 5 times, issued interim resolutions calling Greece to comply with these judgments and to register the associations and open the way for the registration of the other 2 associations. Unfortunately, till today, this hasn't been done. What is even worse is that after the issuance of the judgments by the European Court of Non-Human Rights, these, of course, associations were not they did not operate. So we had to find a way to recognize them and to recognize both the Union of Xanthi, the Turkish Union of Xanthi, and the other 2 associations. And I believe that even today, without the amendment into this article dated from 2017, I think that the national courts, the domestic courts, could have decided to allow the registration of the associations and to allow the operation of the first association. But this was not the case. And so what did Greece used to say? Greece used to say that, okay, in our administrative and criminal courts, we have provisions saying that if somebody wins at the court of the European Court of Human Rights, then he can refer the case to the domestic courts. And in 2017, 9 years had elapsed since the judgment of the European Court, but nothing had been done. And in 2017, we all know how this amendment passed and how it was initially tabled to the parliament and how the then government, how the deputies of the ruling party criticized this amendment and said that if this amendment is voted, we will withdraw. And unfortunately, the amendment that passed didn't make any changes. In reality, the same the amendment that was approved repeated exactly the same thing as the previous law. And the European Court saw clearly if could see if the associations, if these associations created, posed a threat for the public order, and it ruled, it decided that they didn't. So what happened after 2017, after the adoption of the amendment? For the first association, the Union of Xanthi, a request for revocation of the decision was lodged, and the same thing for the other two associations. At the Court of Appeal, in the case of the Turkish Union of Xanthi, the appeal was rejected on the ground, on the ground that the association had made an appeal in 2009 when the European Court had issued the favorable rulings, judgments for this association. Of course, after we lodged a rebuttal, which was heard in 2020, and we are waiting for the judgment. We hope that it will be in favor of us, and we hope that the Turkish Association of Xanthi will be recognized. And as for the other two associations, on the 22nd of March of 2022, actually 18th of March, before the Supreme Court, we will see what will happen. Of course, I checked even today, this morning, if the judgment of this decision is issued. We're very anxious. Unfortunately, it hasn't been issued so far. And we hope that the judges will leave aside all the political issues and rule taking into account the actual situation, because this is a long story. This association has experienced so many issues all these years, and all these people suffer all these years because we shouldn't forget that other associations which use the POMAC and Roma in their title are indeed recognized, while the association bearing in their name the word minority are not recognized. There is no threat whatsoever posed by these associations. The members of these three associations have demonstrated that they do not consider, that they do not pose any threat for Greece. On the contrary, we fulfill all our obligations, and that's what we will continue to do in the future. That's all from me now. Thank you very much for your patience. Thank you. I'd like to stress what he said, that the judges will put aside all the political issues and that they will decide based on law and human rights. So I would really hope that this will be the case. And what was striking is what Mr. Karas said, that he checked this morning if the judgment was issued. And Mrs. Yanakaki and the others smiled. I don't know, maybe they have something in mind. So now I will give the floor to Mr. Panagiotis Dimitras, Mr. Dimitras, who is the spokesman of the Greek Helsinki Monitor and member of the board of the European Implementation Network. He was born in Athens. He graduated from the University of Finance and he postgraduate studies in Harvard universities, lectures in American and Greek universities, and also associate professor at the University of Athens. And he had to resign. He was forced to resign because he's involved in the human rights of minorities in Greece. He's an author of a book, and he's a founding member of the Greek team for the human rights of minorities. And he's member of the Secretariat of the Greek Helsinki Monitor, and he's a member of the board for the execution of the judgments of the European Court since 2018, member of the Executive Council of the Organizing Confederation since 2014, and Secretary General since 2020, and member also of the General Assembly of the International Association Against Torture since 2004. He is someone who is very well established in the field of human rights of minorities, and he is very well known among the members of the minorities of Western Thrace, and I'm sure that he has very interesting things to share with us. Panagiotis, you have the floor. Thank you. I didn't realize that we would be able to speak in Greek, so I have a presentation in English. So I've prepared this presentation, and you will have to listen to it in English.
The Council of Europe Committee of Ministers, and I am quoting, called upon the Greek authorities to take legislative measures either by allowing the reopening of proceedings in civil matters or by changing the procedure for registration of associations, while bearing in mind the findings of the European Court in this group of cases, and decided to resume examination of this item in September 2017 in light of the concrete information to be provided by Greek authorities. Also decided to instruct the Secretariat to prepare an interim resolution in case no tangible progress has been reported by them. Greece avoided the interim resolution by introducing in October 2017 the amendment that Ahmed Kara mentioned before, which supposedly allowed the reopening of the cases. And the Committee of Ministers considered it tangible progress, so there was no interim resolution. So on the 24th of November in that year, 2017, I made a presentation to the Committee of Ministers on the execution of the Bekir Ousta and the House of Macedonian Civilization cases. That's the second one is about the Macedonian Minority Association, also banned. And I said then, so 3.5 years ago, Greece's failure to execute the judgments finding violations of the freedom of association of 3 ethnic Turkish and 1 ethnic Macedonian associations reflects the fact that Greece is the only European country whose administrative and judicial authorities do not recognize or even simply acknowledge the existence of the ethno-national Turkish and Macedonian minorities. If these associations or other Turkish or Macedonian associations register or re-register as a measure of execution of these judgments, this will be tantamount to recognition, or at least acknowledgement, of the existence of these two minorities, and it will be tantamount to a reversal of Greek policy. I added that we had documented this interpretation of the court's stance by submitting to the Committee of Ministers two recent judgments at the time in 2017 that rejected the registration of the new Turkish association that you should not forget, especially in this panel, the Cultural Association of Turkish Women in the Prefecture of Xanthi, and the rejection of the registration of the famous or notorious House of Macedonian Civilization for a third time. And very important, these decisions said that the registration was rejected because, and I quote, there is no structured Turkish minority, and there is no Macedonian nation, no Macedonian culture, no Macedonian language, and no Macedonian minority. That's the crux of the story. Greece put great emphasis on these amendments. And I argued then that they were not so important because of what happened in Parliament. Ahmed Kara mentioned it briefly before, because the first amendment allowing the reopening introduced by the government made the admissibility of the application to revoke the previous judgment binding for domestic courts, which then had to go looking at the merits of the application. After all the things that happened in the parliament, that was amended, and as Ahmed Kara said, the amendment added that was subject to the terms and restrictions provided in the relevant provisions of the European Convention of Human Rights concerning the protection of national security, public order, crime, health, morals, and also the rights and freedom of others. And just to make it worse or more ridicule, also the restrictions or other international conventions, which, by the way, is the wrong term. They meant treaties, and they meant Treaty of Lausanne. So, and in that debate, it was clear that all this got happened because Syriza was left alone, and therefore they had to amend it. And in that case, all non-extreme, I mean, in not Golden Dawn, political parties voted the amendment, but the message was there. The 4 Turkish minority MPs did not vote that amendment. I think it was probably the first time that they departed from their parties. The restrictions had been taken into consideration by the European Court before, and the court had rejected these restrictions that the Greek government then reintroduced in the legislation. So actually, they did that so that to make sure that the Greek courts have an additional element to persist in refusing the registration of Turkish and Macedonian minority associations. And this is what is happening. So then, in November 2017, we urged the Committee of Ministers to conclude that the amendment did not correspond to the demands of the Committee of Ministers, as it didn't, in effect, allow the examination of by the Greek courts of the applications for registration of the associations. So the Committee of Ministers was also requested by us to recall that it was then 20 years, now 23, since the first judgment of the House of Macedonian Civilization, and 13 now years since the judgments of the 3 Turkish associations. And the Committee of Ministers was also asked to take into consideration that in this 20-year period, 23 now, all UN treaty bodies and Council of Europe institutions, like the Commission for Human Rights and the Parliamentary Assembly of the Council of Europe, had issued recommendations asking Greece to register these associations and or to recognize the corresponding ethnic Turkish and ethnic Macedonian minorities. Greece had opted to ignore all these recommendations as well. So, fast forward, as Ahmed said before, the Appeals Court of Thrace in 2018 through 2020 rejected all 3 applications for reopening of the cases, actually considering that they infringe the ne bis in idem principle because the applicants had already requested them in 2008, 2009. The provision introduced in 2017, amending that article, was considered not to apply to all cases, applied only to those who had not made such request before 2017. So all 3 associations have appealed to the Court of Cassation, and the Committee of Ministers, which was informed in September 2020, made a double recommendation on the Bekir Ousta cases, and I quote, urge the authorities to ensure that the Turkish Union of Xanthi appeal is decided upon promptly and in full effect and compliance of Article 11 of the Convention and the court's case law, and urge the Greek authorities to take the same action in respect of any proceedings concerning the other 2 applicants, should it transpire that they have also sought to appeal to the Court of Cassation. As it stands now, this double recommendation is ignored by Greece. The Court of Cassation heard the Turkish Union of Xanthi case in October 2020. Actually, in a strange development, the court changed the judge rapporteur. It's listed in Solon. Until today, most importantly, literally until the time that Ahmed was speaking, I was checking the Court of Cassation's website, it had failed to issue the judgment. As for the other 2 appeals, the Court of Cassation gave hearing dates in 2022, whereas other appeals introduced at the same time were given hearing dates in 2021. And those dates actually initially were kept secret for a few months, but were known to the government. So it is plausible to believe that the government sought such days so as to keep claiming to the Committee of Ministers that they should wait for the completion of all 3 trials at the Supreme Court, which will happen in late 2022 or early 2023, before they can evaluate if the amendment produced tangible progress. We have repeatedly urged the Committee of Ministers to ask Greece to take legislative measures to change the procedure for registration of associations, which was the second recommendation in March 2017 of the Committee of Ministers 4 years ago. Greece, we argue, should follow the example of North Macedonia and Bulgaria. These 2 countries replace the court registration of associations, a procedure like the one we have in Greece now, with government registration authorities complying to the European Convention, which the only thing they do is they check whether the formal requirements, the address and names of the founding members, etc., are correct, and then they register the associations without court decisions. That they did as execution of the general measures of the court judgments for 1 Bulgarian minority association in North Macedonia and several Macedonian minority associations in Bulgaria. Such change of legislation in Greece does not require more than a few months and perhaps a couple of months to set up the new government registration authority. So if that recommendation is followed, it is possible, or it would have been possible because it won't be followed, all associations of the Turkish and Macedonian minorities to be re-registered by the end of this year. That would indeed be tangible progress that the Committee of Ministers would welcome. This will not happen, however, unless the Committee of Ministers decides in its March, that is next week, session to instruct the Secretariat to prepare an interim resolution to be circulated in case no tangible progress has been reported by June 2021 or the latest September 2021 and be decided. An interim resolution, for those that do not know, is almost the equivalent of a conviction that the European Court makes on such cases. That should happen. I don't think it will happen because Greece had shown to be able to influence very much the Committee of Ministers, but this is what we should be pushing for and asking all our allies and asking all the members of PACE and all the friendly diplomats to put pressure on Greece, because otherwise we'll have another webinar like that in 2 years or another meeting in 2 years in Xanthi, and we'll be just reading the same text except adding the years from 20 to 25 and from 10 to 15. Thank you.
Ευχαριστούμε πάρα πολύ τον κύριο Δημητρά.
Thank you, Mr. Dimitra. From what I understand from his presentation, I can tell that we have some future. We have future. So I hope that this policy will change. Thank you, Mr. Dimitras. Mrs. Yanakaki will be the following speaker. A few words about Mrs. Yanakaki. She's expert in human rights specialist, former Member of Parliament and former Secretary General for Human Rights at the Ministry of Justice. She was born in Athens. She graduated from the Onidios School and graduated philology and political science at the University of Athens. Then she went to Paris at the University of Sorbonne for postgraduate studies at the Paris Dauphine University. Also, she is a holder of a second postgraduate degree in human rights from the Robert Schuman University in Strasbourg. Between 2004 and 2009, she was at the permanent delegation of Greece in Strasbourg at the Council of Europe and the European Parliament with press communication and cultural competencies. She was elected member of Parliament in 2012, and she left in 2016 from the party, the Left Party, and she was Secretary General of the Human Rights Committee. Mrs. Yanakaki, we are ready to hear what you have to tell us. Thank you very much for the invitation. I would like to thank you for the kind invitation and to congratulate the organizers on their initiative. We keep on discussing the same things. And as you read, I was at the permanent delegation in Greece many years ago. And we were, back then, we were discussing exactly the same things. And now we have an interim resolution. And once again, Greece consumes a lot of assets and time and resources for these 3 cases. So I will say a few words before I move on to the presentation. I have the role of being the one who drafted the first amendment of the Code of Civil Procedure, which was not the one that was tabled in the Parliament. It was something else that changed. Mr. Kara, I can see Mr. Kara laughing, but this was some of the most difficult moments of my life, because I could see my picture on the newspaper, and the members of the Syriza party where I belonged criticized me. But I drafted one text, but the text that was tabled to the parliament was different. And of course, the previous speakers explained what happened in order to vote the amendment. And let's be clear, as Mr. Dimitras said, the Greek governments of the time, both the previous ones and the current one, do not want to solve the problem, but they're trying to win time. They're trying to find ways to make things pending for a couple of years, hoping that they won't be called to settle this problem. So the title of my presentation has to do, of course, with execution of the judgments, how the judgments are or should be executed by the Greek government. And I will speak about this in order to show the difficulties in both the legislative, executive, and judiciary levels. Mr. Kara, from his experience, has already, as a lawyer of these cases, knows all these things. So Article 46 of the European Convention on Human Rights requires from the 47 participatory signatory states to comply with judgments of the court in which they were parties. And the European Convention establishes a unique tripartite control system for supervising the execution of these judgments. Namely, we have three parties: the European Court, the states, and the Council of Ministers. So with this system, each state controls and is controlled, and as a result, the execution of judgments of the court is ensured to a significant degree. Compliance as a procedure is carried out by the state at its discretion, but the members the state is the one that chooses the appropriate measures. However, effectiveness and adequacy of these measures is judged by the executive body of the Council of Europe, the Permanent Representatives Committee, which oversees compliance and meets every March, June, September, and December. So in its next meeting, it will also address the cases we're talking about. So some facts. So there are 735 appeals against Greece that are still pending at the European Court. In the period of 2017 to 2019, surveillance ceased in 311 cases. Today, there are 186 unenforced judgments of the European Court. 72 cases were violations of human rights. 105 cases are under simple surveillance, while 9 hadn't been included. So what happens once a conviction is issued for a country? It is translated and notified to all competent service and to all the courts. As I will tell you later on, part of my job is to disseminate the judgments. So I compiled all the translated judgments and I disseminated them to all the national courts in order for them to become aware of them, take note of them. there are two categories of measures that the member states needs to implement, the individual and the general ones. The individual measures concern the applicant. The aim is to remedy the consequences of the violation that was made by the state in order to remedy the situation and to restore the situation, the original situation. Where this is not possible, then there is non-pecuniary damage and compensation for any material damage that is paid. So individual measures also are also the full execution of the national court judgment or the repetition of the trial. The most difficult part of compliance, however, is taking general compliance measures, as these require policy initiatives, appropriate policies and socioeconomic conditions, changes in the legislations, etc. So within 6 months of the final judgment of the court, an action plan is forwarded to the Council of Ministers for the individuals and general measures that Greece intends to take in order to comply with it. Non-compliance or not implementation of the action plan results in the issuance of critical interim resolution by the Committee of Ministers. The state can still be referred again to the European Court based pursuant to Article 4 of paragraph 4 of Article 46. It's true that in the recent years, an effort was made since 2010 for the country to comply with judgments of the European Court. And these efforts that are being made are made by the legislative, the executive, and the judiciary power. For example, the legislative power, 4 changes were made in the Constitution in 2001. And the obligation of the central administration to comply with court judgment was introduced within the context of this change in the Constitution. And the law 3068 of 2002 was established, and also Article 4 was added, giving the possibility of conscientious objectors to opt for an alternative way of doing their military service. And we had a case of conscientious objector. So there was a decision regarding the Tsirlis and Kouloumbas case, which gave way to an amendment because the conviction of Supreme Court didn't take into account the case law that Jehovah's Witnesses are known as religion. Finally, in the 2008 revision, due to the Liquideus judgment, Article 55 was amended. And the full incompatibility of parliamentary capacity was abolished. Also, there were some other provisions of the Code of the Political and Civil Procedures and the Civil Code that were amended to allow the retrial before administrative and criminal courts. in case of convictions of convicting judgments by the European Court. Also, Article 137 of the Criminal Code was amended. Article 171 of the Code of Civil Procedure was amended, which provides for the violation of the rights provided by the European Court on Human Rights as a ground for absolute invalidity. And there were some other amendments. Some other actions taken in this context were that the ombudsman was appointed as a mechanism for investigating incidents of violence. Now, when it comes to the executive powers, the amendment of the laws may be agreed, but the administration, it's very difficult for the administration to change its habits. And it's very difficult for the administration to learn the laws that it is called upon to enforce. I will give you some examples that will help you understand. The hospital operating in prison of Korydallo joined the NSS, the NHS, and measures were taken to reorganize and strengthen the medical structures and the condition of detention of HIV prisoners. This was a law dating back from 2016, but it was very difficult to enforce because it's very difficult for some people to accept that the conditions do change. And they need to change the way they work, the method of work. We established two specialized directorates of the Hellenic police in Athens and Thessaloniki, in total of 68 offices in Athens and the province to combat racist violence. The National Council Against Racism and Intolerance was established, and many other initiatives in compliance with the decision were made. We worked with international organizations in order to disseminate and train the judges on the new laws, because we need to admit that it's not the laws that breach the judgments of the European Convention, but the case law of previous trials. So the question is, has the judiciary power comply? All these convictions against Greece, what are their causes? Apart from the dissemination, apart from the training that we held in cooperation with international organizations in order to inform everyone on the big laws, we also took the initiatives, and many judges went to the European Court in order to be trained. One issue that we face is that many judges didn't speak foreign languages, and it was very difficult for them to study the reasoning of the judgments. Of course, this is slowly but surely settled, because the young judges have as a requirement to speak languages, and then also in cooperation with Mr. Kralis, we're trying to train the judges. So our conclusions are that, as I said in the beginning, apart from the fears, apart from the fact that there is the judges do not dare to take initiatives. But there are some also inherent difficulties which are related to the Constitution, no initiatives are taken in order to revise substantially the constitution that would allow Greece to fully comply with the human rights. But there are some also a refusal of the administration to comply, and there is also overlapping of competencies, and in the end we are all competent, and in the end we are all incompetent, and it's impossible to say whose fault it is. And the Greece, as I said in the beginning, wastes many resources and ends up not being able to form alliances in order to face other more crucial problems that it faces. Thank you very much. Thank you, Mrs. Yanakaki. All the things that she said were very interesting. Thank you very much. In 2017, you experienced this Kondoni case, how it was discussed at the parliament and what happened afterwards. This was a turning point, I think. And now I would like to say the following. We're done with the speeches. I don't know if there are some questions from the participants, the attendees. They have the possibility to raise their hand. Mr. Ahmed Yildiz. I will unmute him. Mr. Yildiz.
Okay.
You have the floor.
Thank you very much. Indeed, I am the new chairperson of the Turkish delegation to the PACE, Parliamentary Assembly of the Council of Europe. Now I feel more intelligent on the nature of this obstruction of justice, denial of identity by the Greek governments persistently. I thank very much all participants, especially Mr. Dimitra and Mrs. Yanaki. I will follow it, my delegation will follow it closely. But in the essence that indeed Turkey and Greece should have left all these issues behind long time ago. Let me give you an example. Last week we got a briefing from the administration of the Turkish foundations. They briefed us on about the restoration of Greek cultural heritage, return of their properties. So we made a lot of improvement on this, especially on heritage and identity and religious issues. But it seems the trend in negative in Greece is the opposite. I hope Greek authorities will follow the right way by implementing the verdicts, and we will talk to them in the PACE meetings and the Committee of Ministers. Thank you.
Μάλιστα. Ευχαριστούμε πάρα πολύ τον κύριο Yildiz. Ήταν μια τοποθέτηση, νομίζω.
Mr. Yildiz, it was not a question, it was just a remark. We have another question on behalf of Mr. Bunce. I hope I pronounce properly.
Yes. Hello, can you hear me? Ναι, νομίζω ότι ακούμε, έτσι δεν είναι?
I think this worked. Can you hear me? I'm sorry. Okay, I think you can hear me. You can't see me. I'm Ralph Bunch from the Unrepresented Nations and Peoples Organization, and I just wanted, it isn't a question also, unfortunately, but it's a statement as to what I think are the broader implications of this issue. 2016, we were really honored to work with Halit and ABTTF to try and raise this issue at the European Union level through a conference, bringing some MEPs to Western Thrace, publishing a report on this issue. And it's very sad. I mean, some of the speakers have already said it, but it's very sad that we are sitting here almost 5 years later, still spinning our wheels on an issue of such importance. And what I wanted to say was that since 2016, when we looked at this, I think the issue has become of greater importance beyond the borders of Greece and beyond the impacted communities. What we've seen, unfortunately, in the last 5 years is a spread of this type of approach by governments to restrict civil society space. Obviously, we all know what's happened in some countries like Hungary, Bulgaria, Romania in this regard, as well as to restrict the voices of minorities in Europe. Very specifically, we work with a Savosian NGO in Savoy in France that was recently ruled illegal, and much like the civil society organizations in Western Thrace, had its listing, had itself delisted as an NGO on the basis, according to the French courts, that the French constitution does not recognize minority groups and different groups. It only recognizes one unified French identity. And that as a result, this NGO, the Direction aux Affaires Savosiennes, was not able to be registered or continue to be registered in France. And unfortunately, it seems like we're seeing this spreading beyond the boundaries of Greece and beyond the boundaries of Western Thrace, whereby there's a greater willingness and ease with which governments can target minority rights organizations in Europe, including, as we've seen, as mentioned, in France, and what we've seen that's happening in Spain, vis-a-vis the Catalan civil society leaders, Jordi Sanchez and Jordi Cuixart, who are in jail. And I wanted just to emphasize that there's common ground to be had with groups outside of Western Thrace about this issue, and to highlight, I think, the broader strategic importance for the European Union of this. One is the spread of, unfortunately, the targeting of minority rights groups, the challenges for rule of law across the European Union, as well as the broader challenges that the European Union faces in trying to spread its influence overseas, where it's harder and harder now for the EU to be heard in countries like China, Laos, and otherwise, where we're seeing minority groups crushed by authoritarian regimes. It's harder and harder for the EU to speak about those issues when back home we're seeing these issues continuing to persist. So I just wanted to say that and encourage, I think, a greater, broader campaign on this issue and more focus on this issue beyond Greek actors. And at the UNPO, we'd be very pleased to work with you all on that. Thank you.
Fransa'da mesela Fransızdan başka bir şey tanımlıyor. Biraz onu çok söyleyeyim. Şemşediyor musunuz?
Μάλιστα. Ευχαριστούμε πάρα πολύ τον κύριο Μπούντς.
We know Mr. Bunch. He's talking about a campaign, European campaign. Very interesting what he just said. I don't know if there is someone else who could raise another question. I would like to raise a question to Mrs. Yanakaki about all this hustle about 2017. It was like a campaign, if I may call it, against the Turkish Muslim minority of Western Thrace, for the following reason. The draft law had been tabled to the parliament, and within a few days, Of course, the right extremist party contributed to this. This amendment was renamed. It was presented, if we may call it, as a destruction of the country. So people were saying, no, we cannot recognize this. It will be destructive for the country. I think that back then you were the Ministry of Justice and you were the person who played the most important role in preparing this draft. What can you tell us about that period? I had spoken to Mr. Dimitras and some other people told me that that I wouldn't have a future, that all my efforts would be in vain. And back then I said that some initiatives had to be taken. This amendment well, I expected it to be even more noisy, if I may say, because the bill of law could trigger frustration. And well, there was a newspaper, the Proto Thema, and some other newspapers followed, but I expected to trigger more reaction. And the New Democracy was, well, this amendment, of course, was not the first one, was not the original one. And even the New Democracy Party, except from Mrs. Bakoyani, and I need to stress that, and it is something positive for her, because she has a long experience and she knows exactly that the country is humiliated when things like that happen. So the New Democracy told us that we want to violate the Treaty of Lausanne, and the decisions in favor of registering the association would be destructive. And I think that this is a field, a fertile field for populist views. There was something else that I had in mind. Politicians forget that until 1974, the minority was called Turkish, until the arrival of the dictatorship. And in the period from 1927 to 1983, this association operated normally. It was not disturbed. So the minority is unfortunately an easy victim of political games. And this will always be the case. We as government didn't manage to do something very easy to transfer the issues of the minority from one minister to another. And there was a great failure of us. And we should self-criticize. It's a issue of self-criticism. And when it comes to an issue like this one, we need first to say what we failed to do and then what we managed to do. And the reaction of the Ministry of Foreign Affairs to transfer all these issues to the Ministry of Interior was striking even for me. Yes, all the things that you tell us are very interesting. We shouldn't forget that in 2015, when the Syriza came to power, January 2015, the expectation of the minority regarding problems, long problems, was very important. But with the course of time, we lost all the expectations and we went back to reality. So the case of the Turkish Union of Xanthi and the other association dating back from 1983 and even after the judgment of the European Court in 2008, we're talking about 13 years almost. So these have been very tiring years in this respect. And to conclude, we could say that the case of the Turkish Association of Xanthi and the other associations is, according, in our view, is a case which reflects the policy of the Greek state toward the Turkish minority of Western Thrace. It is a marathon which is still underway regarding the respect of human rights. What remains to be seen is to execute, to seek Greece executing the judgments issued by the European Court in order to, because now we are on the 13th year. So hopefully, let's hope that we will finish with this shortly. Let me tell you also that what needs to become very clear if we want to be seen as a serious country, we cannot talk about an a la carte, a selective execution of the judgments. Because if we make a selective execution, we cannot ask from Turkey to execute the judgments regarding Cyprus. We must serve as an example and execute all the judgments in order to be able to tell our neighbors to do the same. Mr. Dimitras has something to say. Yes, just two words, Mrs. Yanakaki. Mrs. Yanakaki was indirectly involved when efforts were made for the second time in a row to pass a bill. And of course, we need to be honest. When the Syriza government took office, you were not very honest because you were very enthusiastic about the result, but you, ever since, no progress was made. Are you aware of what happened last week with Mr. Velopoulos? when Velopoulos said, you brought the European directive to the media and the AH includes members of the national minority, Velopoulos proudly said that finally they had to surrender and they abolished the charter because they abolished the charter being in panic, and Maria has already experienced that. And the bill that was tabled to the parliament was mistakenly a previous version. This is what happened last week. Velopoulos managed to do that against the 300 members of the parliament. So as long as it is not imposed to Greece to recognize the identity of these people, so as long as this is pending, every extremist and anyone from the extremist parties from the Golden Dawn Party. So these extremist parties can impose themselves on the mainstream political parties, and this is really bad. Yes, in order, we need to be very honest with ourselves. So there is an extreme right mentality that can be seen horizontally to all parties. When I tried to explain to the members of Syriza and ANEL the amendment, I expected that ANEL members, I expected anything from the ANEL. But when I went to the Syriza parliamentary members, I heard them say things that I never expected them to say. And I was wondering, am I in the same party as they are? How could it be possible? I remember Mustafa who came to say that I cannot vote this. I cannot vote for that. So I remember, however, that there were members of Syriza. They thought that was a friend of Turkey and that I had put something in the text that would be very harmful for Greece. Thank you, Mrs. Yanakakis. Mr. Kara has something to say now. A short remark. I'd like to thank Mr. Yanakaki and Mr. Dimitras for everything they said, because all the things they said were very important, enlightening. We clearly understood what the situation is, because of course we knew what was obvious in the eyes, but we're not aware of what was happening behind the scenes. So, as for the Mufti, there was a very strange manual regarding the compliance of Greece to the violations of Article 9 of the Convention. We know very well that in cases that have been closed 10 years ago. Since 2 years, the elected Mufti need to still to go to the court sometimes. Very recently, the Mufti of Komodini was punished, was sanctioned. We need to inform the European Court that this remark did not match to the reality, did not correspond to the reality, because here, even today, we still experience this problem. Thank you very much, Ahmed. Thank you, Mr. Kara. I think that we're reaching the end. That was a very interesting event, an online panel of great interest. I'd like to thank you all, hoping that one day soon we will see the sign of our association on its place, back to its place. At this point, I'd like to thank Mrs. Maria Giannakaki. Thank you very much for the invitation. So I'd like to thank Mr. Dimitras, Mr. Kara. I hope that many other people will have the possibility, because it's being broadcasted. And I'd like to thank also the organizers, the Federation of the Turks of Western Thrace, the Greek Helsinki Monitor, Mrs. Houliaimi, all the technicians behind the scenes, all the participants. I wish you a very pleasant evening. The spring is way ahead, and we hope that we will not have to wear masks this summer. Thank you very much. Bye-bye.